Most of the discussion in this video to date has been situations where somebody was under audit or they were under criminal investigation. If you're dealing with a situation where you've got criminal exposure for tax returns you filed in the past and there's some reason why you would like to fix that before that fraud is discovered, you can't sleep well at night, your soon-to-be ex-wife's forensic accountant just discovered your fraudulent tax returns in a divorce proceeding, your soon-to-be business partner has learned that you've committed tax fraud by reviewing the records and is threatening to whistleblow against you, etc., etc. You have exposure, but the time bomb hasn't gone off yet. Here's a solution that you might want to consider. Under the government's voluntary disclosure policy, published in the Internal Revenue Manual, a taxpayer who in essence admits to a potential tax crime by filing an amended or delinquent return may avoid prosecution provided the disclosure was voluntary and made before the taxpayer was first contacted by the IRS regarding a potential problem with the tax liability. Now, a couple things to say about this. First of all, don't confuse a quiet disclosure with a voluntary disclosure. A quiet disclosure is where you sneak a bunch of amended returns in front of the government that are fixing a criminal issue, but don't bring notice to the fact that criminal activity may have occurred. A true voluntary disclosure is only initiated when you approach the Criminal Investigation Division of the IRS directly and potentially admit to them that fraud may have occurred. Now, while you probably get a pass from criminal prosecution, matter of fact, there's only a couple cases in history where voluntary disclosures have blown up. This is where a client has been caught cheating in the process of getting clean. Don't do that. If you enter this program, it's a one-way trip, and you must comply with the terms of the program or you can wind up causing a much bigger problem than you're trying to fix. What you need to realize here is if you file amended returns right at the outset of an audit, here's how the government's going to react to that. Amended or delinquent returns filed after a taxpayer has been contacted by the IRS do not qualify for the voluntary disclosure policy. Even though the courts tend to hold that the filing of a delinquent or amended return or the late payment of tax is admissible by a defendant on the issue of willfulness. A lot of courts will look at this and say those amended returns are basically an admission of guilt and a roadmap back to the fraud that was committed originally. So don't confuse a quiet disclosure with a loud disclosure. A loud disclosure, knock, 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 Criminal Investigation Division of the IRS. Quiet disclosure, slipping into a service center. The bottom line here is that the filing of an amended return after you've been notified that you're under criminal investigation or under audit is a patently bad idea. Don't do it without consulting a criminal tax defense attorney. Case law shows that the IRS looks at amended returns, picks out the roadmap that leads back to the non-compliance that existed in the original return, and will prosecute on that, especially if you're dealing in a situation where you got a foreign account and you've done a quiet disclosure. I've got a separate video series on that.